Good morning. It's a great honor to be invited to speak at this program by Vicky. And bios aside, I think what you really need to know about me is that I am a voracious reader, and I'm also a world traveler. And traditionally, those two things sort of butted up against each other, because I would find that when I went on my travels, I always had to have at least 3 books with me. I'd have to have the book that I was reading, and then I'd have to have my backup book, and then I'd have to have the backup book in case my backup book didn't work out. And even with those 3 books in my suitcase, one of the first things I did, even on a very short trip, was to find the local bookstore. Because in experiencing the local bookstore, I felt that I could find out a little bit more about the culture of the place that I was visiting. Well, this has been the way I've done things for quite some time, but then there was a massive frame shift, because in around 2007, I bought a Kindle, an Amazon Kindle. I had one of the early ones. That was a lot more expensive then and less easy to use. But I bought a Kindle because suddenly, for the first time in my life, I could carry 1,500 books with me anywhere I went. And the whole idea that I had that capacity was astounding to me. Now, when I'm in my country, one of my favorite ways to get books is to use libraries. Now, I know India has a public library system. In the United States, we have very active public library systems, although they are constantly being challenged in the area of funding. There are approximately 9,000 public libraries with 1,600 separate branches. And in addition to these, there's lots of other things that we call libraries. They could be at educational institutions, government organizations, or private sector organizations. Libraries are important in have that function of loaning books or of providing books that the public can come in and read. However, in the United States, and I think increasingly around the world, one of the things that we have discovered is that many of our public libraries report that they are the only source of free public computer and internet access. So for the many Americans who don't have a home computer and maybe don't have access to a computer at work, library is really the only place they can go. In the United States, we don't have internet cafes in the way that they exist in many other countries around the world. So libraries have a key function in the digital age in providing those services. In addition to that, a library remains an important third place. What do I mean by a third place? I don't mean that it doesn't come in first or second place. A first place in the mind of one architectural philosopher is your home. Your second place is your workplace. And a third place is a place where you go to socialize. Perhaps you go have food. It provides a social function that the first place and second place cannot provide. And libraries as institutions are key third places. And that role is evolving in the digital age. Also, another factor in the digital age is that library collections are moving from the physical to the virtual. I think in 2011, it was the first year that Amazon, which is the largest bookseller in the United States, sold more ebooks than they sold hard books. We found that around the United States, unfortunately, and I'm incredibly sad about this, bookshops are closing at a really rapid rate. Even in the large cities, we're going from having 10 bookstores to maybe 1. Much of the way that we get books, even the physical books, is through Amazon. So in 2011, they sold more ebooks than they sold physical books. In 2012, the same became true for UK Amazon. And why is all this happening? Well, storage is faster, larger. more compact, less expensive. There's rapid changes in communication and display technologies. As an early adopter for technology, I was really excited when ebooks came out because I found that I could read an ebook on my mobile phone. I actually used to read an ebook on my Palm Pilot, for those of you who remember the Palm Pilot, because I loved having access to a book that I didn't have to carry around with me. And however, the new ebook readers with e-ink technology are so much easier to read and look at, and it's just a complete transformation from trying to read something, say, on a reflective computer screen. Obviously, the role of the cloud is incredibly important in the digital age. Having storage that doesn't have to physically be located in the facility where you're delivering the content. And increasing content interactivity, as the previous speaker spoke of a great deal. I'm going to talk briefly about the US copyright law and what we've done for libraries to make libraries the institutions that they are, and then how that's changing in today's world. And in particular, I'm going to talk about two cases that have been of great interest internationally, one being the Google Books case and the other being the Hathi Trust case. In the United States, as in India, traditionally use of copyright materials is restricted. The author has what are called exclusive rights to allow others to use their works. And there are certain limitations. For example, works that are in the public domain, including works that for which copyright has expired, or for example, this PowerPoint is a US government employee created work, and therefore there is no copyright in this PowerPoint, and I'm happy to email it to any of you that want to come after and talk to me. In addition, we have special exceptions for libraries in Section 108 of our copyright law. And Section 107 is the sort of basic exception and limitation in our law having to do with fair use, which is slightly different from the Indian concept of fair dealing. I'll talk a little bit about fair use later. But essentially, in the absence of an exception or limitation, all uses of a copyrighted work require authorization from the copyright owner. Well, in the case of libraries, that can create some challenges. So in Section 108 of the Copyright Act, we have a number of exceptions that permit libraries to copy unpublished and published works. 108B permits copying of unpublished works for preservation. And 108C allows copies to be made of published works to replace other published works. There are conditions that are required here. Reproduction, distribution must be made without any purpose of direct or indirect commercial advantage. The library has to be publicly open, and reproduction or distribution must include a copyright notice. Well, in 1998, the United States went through its major copyright law revision and enacted something called the Digital Millennium Copyright Act, or DMCA. Just this year in 2012, India has enacted its major copyright law change. The two are somewhat similar in that the DMCA was intended to implement the WIPO Internet Treaties, which are the WIPO Copyright Treaty and the WIPO Performances and Phonograms Treaty. Now, prior to the DMCA, Section 108 made the allowances that I mentioned. However, there were some new provisions that were put in 108B with respect to unpublished works. Now the library was permitted to make up to 3 copies, including digital copies. And 108C addresses the reproduction of published works and basically frees up some things that libraries can do with respect to published works. However, even in 1998, I mean, we were really just seeing the beginning of the internet then, and so we had no way of anticipating the world that we're in today. And so even those provisions may need further reconsideration because they're just not up to date now. Now, how libraries work in the United States is if a library wants to use a work in digital format, typically they do so by obtaining a license, and publishers will provide those licenses to libraries. There also is free access to all kinds of information, whether it be on the internet or through special subscription services. Now in the United States, libraries also lend ebooks. I happen to have my first foray into library ebook lending. I've got 2 ebooks that I borrowed from the library for the first time on my Kindle right now, and I have to read them before they expire on September 11th. But it's a very exciting move in the area of libraries. About 66% of our public libraries offer free access to ebooks. And the way that they do this is by providing technological protection measures, or what's also known as digital rights management, that are applied to the e-works that will restrict copying and other unauthorized uses. Typically, the publishers will require that you only loan out a single copy of a ebook to a single reader at a time, and you can sign up online to be on the wait list for works. And the nice thing about it is you don't actually have to return the book to the library. I personally was the major funder of the Alexandria Public Libraries just because of my late and overdue fines that I was paying. But now, with my ebooks, the book just disappears from my e-reader after the deadline has passed. Libraries don't get a complete out from copyright law, though. And so a lot of times what libraries want to do is apply what's called the fair use test. Fair use is a judicially created doctrine, but it has been codified in the US copyright law. And essentially what it is a privilege that a end user of copyrighted material has to use material in a reasonable manner without the author's consent. And it really, I think, is fundamental to US copyright law, because it really, underlying the idea of copyright law is the idea that we want to disseminate knowledge. That's what copyright law is for. It's to create incentives for people to create and then disseminate books and other pieces, other creative works. The fair use doctrine just excuses particular uses of copyrighted works from being infringement, where the social benefits from the use of the work outweigh the loss to the copyright owner. Essentially, what the fair use doctrine says in Section 107 of the Copyright Act is that it allows uses for purposes such as criticism, comment, news reporting, teaching, scholarship, or research. And it says here, such as. So these purposes are non-exclusive. There are other purposes that might be deemed to be for fair use. What the court will look at in determining whether a particular use was fair is a number of factors. There are 4 factors. There's no particular one factor that weighs against any other factor. It's a balancing test. And they look at the purpose and character of the use, the nature of the copyrighted work, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. And just note here that just because a work use is non-commercial does not necessarily mean that it is always fair. It is a very strong indicator of the purpose and character of use. For example, is the use commercial? The other thing that courts will look at is whether the use is transformative. Does it add something new to the work, or is it just copying the pre-existing work? Courts are less likely to find fair use for creative and imaginative works and for unpublished works. Usually, with respect to factual or predominantly factual works, courts are more likely to find fair use. And then the courts look at the amount and substantiality of the portion used in relation to the work as a whole. So they look both at the quantity used and of the quality of the particular segments used. So for example, if maybe you only copied 2 paragraphs of a book, but they were really the key and heart of the book, that could still be deemed to be not fair use. There's really no bright line rule here. And then the fourth factor is one that I think has really affected the courts a great deal, the effect of the use upon the potential market for the work. And this even can be for uses that the author is not making of the work at the moment. Just, you should understand that the analysis here is very fact-intensive and differs on a case-by-case basis. Quickly, another point I want to just address as being a very key issue with respect to libraries in the digital age is the issue of orphan works. An orphan work is a work that is protected by copyright, but the copyright holder cannot be identified or located after a reasonable search. And because of that, users are unable to obtain permission for use of the works. Reasons can be many, publishers going out of business, authors dying and leaving unclear title. Why did I give you all this background on 107, on 108, on orphan works? Well, it's essentially to help give you the platform to understand this very important case of Google Books. What happened here was that Google partnered with a number of libraries, primarily university libraries, to scan entire books to create digital libraries. What they did was essentially back up trucks to the back doors of the library and just take all of the shelves and take all of those books and scan them. Well, the Authors Guild and the Association of American Publishers brought a class action suit against Google for copyright infringement. Now, Google said, look, we're copying all of the books, but all that we're doing in our display of the books is displaying a snippet of the book, just a little bit of the book, so that you can search the term throughout the book, and you'll see the part of the book that has that search term in it, but you won't see the full book. This sparked an international controversy, and in fact, Indian authors were very involved in the case. So what happened was Google and the class members entered into settlement negotiations. And what Google agreed to was that they would pay and would be authorized to digitize books, sell subscriptions to the electronic books database, sell online access to individual books, sell advertising on pages from books, and make other prescribed uses. The rights granted to Google are non-exclusive. There is a book rights registry that is a database of rights holders and helps to administer royalties under this settlement. And rights holders can exclude books from some or all of the uses listed. So this was the settlement agreement that was entered into. However, the court looked at this settlement agreement and said, no, sorry. This settlement agreement is not reasonable. And again, some Indian authors had a part in the judge's opinion actually specifically mentioned some Indian authors' views on the settlement. Essentially, the court said the settlement goes too far. It uses a class action to create a business model, and the class action is about the use of snippets, but the settlement allows Google to use full books. It gives Google an unfair advantage over competitors, and there's some antitrust considerations. It releases all claims beyond just those that were presented in the case. So for example, if you were an Indian author and you weren't aware of the Google Books case, you would be part of the settlement agreement regardless of whether you opted in. And many of the concerns that were raised or addressed by the settlement are better suited for Congress. So this is what the judge said. court also recommended to Google and the plaintiffs that many of the concerns that it raised with respect to the settlement agreement would be ameliorated if the settlement would convert to an opt-in settlement, meaning that authors could say, yes, Google, you have the right to use my books in this fashion, but that the default would be, no, Google, you don't have the permission to use my books in this fashion. So the next steps in the Google case are to revise the settlement, go to Congress, especially for rules about orphan works, or to continue to litigate the case. The case is now proceeding as a class action suit. Google has tried to appeal the decision to certify the class before it goes into full litigation, but the judge just this last week said no, that Google wasn't allowed to appeal that part of the judgment before pursuing further litigation. A related case is the HathiTrust case. Basically, HathiTrust is a group of universities and other institutions that came together to create a large-scale repository of digital content. And primarily, the content is being digitized through Google Books, although some of it is digitized locally by libraries. The Authors Guild came out and sued HathiTrust, saying that its receipt, storage, and use of digital files of scanned books are a violation of the copyrights in those books. This case is very much still an active one. We don't know what's going to happen with it, and we don't know if whatever decision is reached in the Google Books case will solve the problems of the HathiTrust case. But again, this is an area where Indian authors should be particularly concerned, because many of the books in the HathiTrust are from institutions that would have more scholarly kind of literature that Indian authors may have authored. Just a quick question as to how these cases would fare under India's 2012 copyright law. I'll note that fair dealing under the Indian law is much broader than fair use in the United States. So Google's argument that snippets were fair use might well be persuasive. There is a broad exception that allows for nonprofit libraries to electronically store any work that is in their collection. And depending on the interpretation of the provision, there's a new provision that allows exceptions for students and teachers in the course of instruction. I don't know, and I assume there will be case law on this eventually, how that provision will be interpreted. In addition, India is one of the first countries in the world to create a solution for orphan works. They created a compulsory license for orphan works. So all of this litigation likely would not arise in India, or if it did, it certainly would be decided differently than how it is being looked at under US law. Thank you very much, and I'm happy to take questions if you have any. But I also know being the last speaker before lunch is deadly. Sure.
You narrated your story like from transformation from reading books to Kindle. If you could tell us, Indian audience, how easy it is, because I think even in USA, a lot of people faces this problem. Reading book conventionally is a very easy and comfortable way of accessing knowledge or information, while Kindle is still a cumbersome and it's a troubling eyes. How easy was it for you, this transformation?
Well, personally, I would say that the e-ink technology now makes reading a book on a Kindle or other e-reader comparable to reading a paperback book. I don't find any great difficulty. In addition, one of the nice things about having an e-reader is that because of all of the technology that's in it, you can put your cursor next to any word and the definition of that word will automatically pop up. Well, I don't know about you, but I'm a lazy reader. I will often read words in context, have a complete understanding of what I think it means in context, but not bother to actually pull out my big dictionary from the shelf and look up the word. So I find myself actually becoming a more educated reader in the way that I'm able to look at the definitions of words. I'd say the one area where, and I'm actually very happy to be here in India talking about this. The one area that I think is still not quite up to speed is the sort of user interface, or the way that the book looks on the page. I think there's a lot of room for growth there, and I particularly think that it's something that India could be a great country to perfect. Because it's an issue of software, of machine reading, of scanned books. It's an issue of design, and it's an issue of just resources to be able to review books, to make sure that mistakes aren't in the books, which didn't happen as much in the case of print books. So I think that's a great area for expansion in the ebook world.